an inmate, already serving 10 years, with 4 left to go, shackled, facing a brand new felony charge for allegedly assaulting a corrections officer. And on the very day his jury is sitting downstairs waiting to be brought in, he drops a bombshell. I want to represent myself. Meet Aaron Jones. No law degree. No formal legal training. He dropped out of school. And going up against him, a prosecutor with 46 years of trial experience. The judge lays it out immediately. Represent yourself, and you will be held to the exact same standard as a lawyer who's been doing this since before Jones was born. Jones's response: it's only 3 years. He genuinely does not seem to grasp, or genuinely does not care, just how high the stakes actually are. But this hearing isn't just about the legal chess match. It's about shackles the jury isn't supposed to see. It's about a defendant who asks for a bathroom break not once, but twice, in the middle of a constitutional rights hearing. It's about a standby attorney he insists he doesn't trust, right up until the moment he changes his mind, decides he wants real counsel, and then flips back again in the span of about 90 seconds. By the end of this hearing, we're going to see a masterclass in exactly how far a judge has to go to protect a defendant's rights, even when that defendant seems determined to work against his own interests at every turn. Let's get into it.
When I'm talking, you do not talk over me. Do you understand that?
Yes, sir.
You're not going to misbehave in my courtroom. You're not going to misbehave in front of this jury, because I'm going to tell you right now it's going to end very quickly and very badly for you if you do.
Your Honor, my client has indicated to me that he might want to represent himself in this matter. I just wanted to bring it to the court's attention to have the court address that issue.
All right, Mr. Jones, why don't you tell me what's going on?
I just want to represent myself. I feel like nobody's going to fight for me like I'm going to fight for myself. I've been through voir dire, I've been through jury trials, I've done all this before.
Do you go to law school?
No, I do not, sir.
So do you know all of the rules of evidence and the rules of criminal procedure?
I don't think I really need it with this case.
Yes, you do. You absolutely need them, because every time something happens, Mr. Arnold here has been a practicing trial attorney with the prosecutor's office in Hamilton County and Warren County for how long, Mr. Arnold?
Well, if you add in military time, almost 46 years.
46 years.
Let's pause on something the judge said that's easy to miss, but massive in consequence. If Jones represents himself and loses, he cannot appeal later by claiming his lawyer did a bad job, because he won't have one. That's called ineffective assistance of counsel, and it's one of the most common grounds for appeal in the entire criminal justice system. By choosing self-representation, Jones is voluntarily giving up what could be his single biggest safety net if this trial goes badly. And notice the math he keeps repeating. It's only 3 years. That's Jones anchoring himself to the low end of a sentencing range while seemingly ignoring that the actual maximum, as we're about to hear, is 36 months for a third-degree felony assault charge tied to his status as an inmate and the location of the alleged incident. When someone's already serving time, 3 additional years can sound almost irrelevant. But to a judge whose entire job is protecting due process, that math is exactly what should worry Jones the most. Here's the question worth sitting with. Is Jones's confidence rooted in real trial experience? Or is this a man who's underestimating exactly what he's about to walk into?
He's a skilled trial attorney. He knows the rules of evidence and he knows the rules of procedure. You can roll your eyes at me all you want.
I don't really care about none of that.
But here's the problem. I'm required by my canons that I hold you to the same standard that I hold Mr. Arnold, even though you have no formal training or education in the law.
All right.
I'm sorry?
It will be all right.
It won't be all right. I'm telling you, you won't.
Man, it ain't no time, bro. I got 10 in with 4 left to do. I do not care at all, even a little bit. It's 3 years. It's cut and dry. What happened, happened. I didn't start this. Let the jury decide. I don't care about none of that, bro. None of the stuff you talking about right now make any sense to me. Do I care about it at all, even a little bit, man? It's 3 extra years max.
So what are you telling me?
I'm telling you, I can represent myself. I can handle it. It's not that serious.
Ms. Martin is a skilled trial attorney.
That's cool. I might be a skilled trial attorney too. Sometimes you gotta try stuff in life, and you never know how good you might be at that.
You ever picked a jury before?
I have. I've been through mass of those. I've been through at least 7 different ones of those. Some of them didn't go all the way through. People got sick and stuff like that. Had to do it all over again.
You realize that if you do this, you cannot use...
This Shackles moment deserves its own spotlight, because it's a genuinely fascinating piece of trial procedure most people never think about. If a jury sees a defendant in restraints, that visual alone can be grounds for an appeal. The reasoning being that shackles imply guilt and danger before a single piece of evidence is presented, which undermines the presumption of innocence. That's why the judge works out a logistics plan on the spot. Jones will do his questioning, opening and closing from the defense table, hidden behind a skirt or bench so the jury never sees his legs. What's remarkable is that Jones immediately understands the strategic implications. He even jokes it's kind of like a tipsy juror type of thing, showing a level of legal instinct that doesn't quite match his earlier claim of having no formal training. It's a genuinely strange contradiction running through this whole hearing. Moments of real legal awareness, sandwiched between moments where he insists the entire process barely matters to him. So which is it? Is Jones more legally savvy than he lets on? Or is this just confidence without real understanding? Keep watching, because the next stretch of questioning is about to test that theory directly.
You cannot use ineffective assistance of counsel as a grounds for an appeal. It's not a basis for an appeal. You'll be representing yourself. You'll be held to the exact same standards that I hold Mr. Arnold to, and it would be a huge mistake.
All right.
I'm
That's
sorry?
Cool.
It's not cool. It's you're making a huge mistake.
I mean, I made a whole bunch of them. I'm sitting in prison right now for something I ain't do, so I make a lot of mistakes. You can't live life with regret, man. You gotta do what you gotta do.
And there it is, the moment that should give every viewer pause. Mitigating circumstances are facts that could reduce culpability or influence sentencing, things like mental state, provocation, or context surrounding an incident. It's one of the most basic building blocks of building any criminal defense. And Jones, on the record, admits he doesn't know what the term even means. Compare this to the competency check we've seen in other self-representation hearings, where judges are required to confirm a defendant's waiver is knowing and intelligent before letting them proceed. Here, the judge is doing exactly that in real time, probing Jones's actual understanding, not just his stated confidence. And each answer is chipping away at the case for letting him go forward alone. But here's what makes this hearing different from a straightforward denial. The judge doesn't just shut it down. He keeps going, keeps explaining, keeps giving Jones chance after chance to either demonstrate understanding or reconsider. Is that patience? Or is it setting up a much bigger problem for later in the trial? We're about to find out.
Well, I'm inclined to decline that request. We are here on the day of jury trial. The jury is waiting for me to bring them down. I'm inclined to allow Ms. Martin to proceed representing you.
I don't want Ms. Martin representing me. I want to represent myself. I don't need somebody that's going to lay down and work with the prosecution. I'm going to do what
Ms.
I
Martin
do.
does not...
I mean, that's cool. Your opinion is irrelevant in this matter. Your opinion is not helping her none. You work with the prosecution. You ain't here for me.
You are incorrect. I do not work with the prosecution. I do not work with the defense counsel. Actually, one of my functions here is to make sure that your constitutional rights are protected, which is what I'm doing right now. I'm sorry?
That will be tested. We will see about that.
The other problem is, obviously, you have a right to remain silent. With you asking questions, and you're making a huge mistake.
It's added to the list. It's a whole bunch of them. It's a long list.
Has anyone threatened you in any way or promised you anything in order to get you to waive your right to counsel?
No. Just want to represent myself. I can't go any worse than it might be about to go. It's only 3 years, man. It's only 3 years. I got that.
And as long as you understand that in asking questions and picking the jury and everything that you do, here's the other problem. Is he in shackles?
Yes.
Okay, there's the other problem. because you are in custody, you have shackles on. You want the jury to see you in shackles?
And that's grounds for an appeal by itself. I realize that part. You're not supposed to let the jury see me in shackles, so, I mean, that's kind of like a tipsy-turvy type of thing right there. I know a little bit more than most. Ain't all the way simple, close to it, but a little bit more than most.
Your Honor, if you're going to entertain this, I think you need a written waiver, A, and a much more detailed, the 12th District, and I can't remember the name of the case, a few years ago, came out with a much more detailed.
All right, we'll go through it. Hang on. All right, Mr. Jones, you've been handed a waiver of right to counsel. You understand that you have the absolute constitutional right to be represented by an attorney. Do you understand that?
Yes, sir.
You understand that you are not being charged for Ms. Martin's services, that you have the right to have an attorney appointed to you free of charge. Do you understand that?
Yes, sir.
And you understand the charge against you is a felony of the 3rd degree assault because of your status, the status of the alleged victim, and the location of the incident being in the Department of Corrections, that the maximum penalty is 36 months in prison.
Correct.
All right. Are you aware of any possible defenses to this charge of this allegation?
Meaning what?
I'm just asking the question. Are
I
you
understand
aware of
the
any?
question.
Are you aware of any?
I don't understand the question you're asking, sir.
Well, you're going to represent yourself and put on a defense, I assume, at least by way of cross-examining the witnesses presented by the state.
Right.
You understand that?
Yes, sir.
All right. You understand that there may be possible defenses that you could raise in your cross-examination of the state's witnesses or in presentation of witnesses on your own behalf. You understand that?
Like impeaching a witness?
Sir, I'm not going to explain every single thing to you. That's why I'm trying to encourage you to go with counsel here. Do you understand?
Yes, sir.
All right. There may be possible mitigating circumstances. Do you understand that?
Huh? No, I don't.
You don't know what mitigating circumstances are? Again, that's another reason why you need to have
3 years, man. That's
I'm sorry?
3 years. That's nothing.
Let me tell you something. If when I'm talking, you do not talk over me. Do you understand that?
Yes, sir.
You're not going to misbehave in my courtroom. You're not going to misbehave in front of this jury, because I'm going to tell you right now, it's going to end very quickly and very badly for you if you do.
It's 3 years.
Well, you're the one that's elected to go with the jury trial, so you keep on saying it's only 3 years. That's fine. All right.
Now here's something you don't see broken down often. The sheer logistics of running a hearing for an incarcerated defendant. Twice now, Jones has asked for a bathroom break in the middle of this constitutional rights colloquy. And both times, it becomes its own small negotiation involving deputies, cuffs, and courtroom procedure. It's easy to focus on the legal drama and forget that Jones is literally shackled throughout all of this. Every practical detail of his day, down to using the restroom, runs through security protocol first. It's also a subtle window into something bigger, the emotional and physical toll of navigating a legal system while in custody. Jones even pauses mid-hearing to apologize for coming off obnoxious, acknowledging he got off to a bad start with the judge. That's a strikingly human moment buried inside an otherwise combative hearing. A reminder that underneath the legal posturing, there's a person trying to manage an enormous amount of pressure in real time. Does that context change how you're watching this? Or does it not matter once someone's making decisions this consequential? Either way, what happens next is the most chaotic stretch of the entire hearing.
All right.
They try to give me 2 of it anyways. Might as well go to trial.
Okay. You understand, and I've told you several times now, if you represent, you will be detrimental, it will be detrimental to your case. You understand that?
I don't know if I believe that. That's your opinion.
It is my opinion, and I'm strongly advising you against it. But you understand that in my opinion, if you represent yourself, it will be detrimental to your case.
Everybody's entitled to their opinion.
Okay. But you understand what I'm telling you?
Yes, sir.
All right. And you understand that if you represent yourself, you're going to be held to the same standards as any other defense attorney and the same standards as I'm going to hold Mr. Arnold. Do you understand that?
Yes, sir.
Have you ever represented yourself before in any criminal prosecution?
No, sir.
And you wish to go forward today without the assistance of an attorney?
Can I get a few minutes? I use the bathroom anyways.
Few minutes for what?
To use the bathroom, think about it, make sure this is what I want to do.
Take him to the bathroom.
Say something real quick, Your Honor. I didn't get that opportunity to use the bathroom. Your officer wouldn't allow me to come out the cuffs. I don't know how I'm supposed to. I don't want to be rude or crude. Like, I know I got off to a bad start with you, sir, and that's not what my intentions were. I'm just kind of obnoxious. I'm sorry.
Yeah, I'm not in charge of security here, Mr. Jones. The
So
deputies and the transport officers are in charge of your security of this.
How am I supposed to use the bathroom in
Sir?
cuffs? How am I supposed to be able to wipe myself in cuffs?
All right.
Your officer refused to move the cuffs when I was locked in the cell. I'm just trying to use the bathroom. I need to use the bathroom before we get started, sir.
Rhodes,
Yes, sir.
what's the issue with him?
I was never asked to remove the towels.
Yes, he was, man. He knew I had to use the bathroom. I don't know what else I'm supposed to say. I need the cuffs.
All right, let's get through this and we'll talk about your bathroom after that. All right. I advise you that you're charged with an assault of a corrections officer as an inmate at the a correctional facility. Maximum penalty, as we've said, is 36 months in prison. After closing arguments, I will give the jury the instructions of law.
This closing stretch might be the most telling part of the entire hearing. Jones flips from wanting to fire Miss Martin to wanting real counsel and waiting for his family, back to representing himself, all within about 2 minutes. And through it all, the judge does something worth understanding. He keeps Miss Martin in the room as standby counsel, even over Jones's direct objection. That's not the judge ignoring Jones's wishes out of spite. It's actually a well-established safeguard. Standby counsel doesn't run the defense. They simply remain available in case the self-represented defendant needs guidance, or more importantly, in case the situation deteriorates and someone needs to step in immediately. Courts frequently appoint standby counsel specifically because self-representation goes wrong so often. Jones's objection is overruled. But arguably, it's one of the only decisions in this entire hearing that's actually working in his favor, whether he realizes it or not. And notice Jones can't say for certain he even read the waiver form he just signed. Admitting he reads depends on how many pictures are on it. That's not a throwaway line. That detail alone should make you wonder just how knowing and intelligent this waiver really was.
Now, the issues that present themselves with regard to you representing yourself obviously is a logistics issue since you are incarcerated. The shackles on your legs will remain. The court is going to make a finding, and again, if you want to have a hearing on this, Mr. Arnold.
Your Honor, I just asked the court to take note that he's previously been convicted of assault on a corrections officer and is an inmate incarcerated for offenses of violence.
So I'm going to make a finding that you pose a security risk to this courtroom. So the shackles on your legs are going to remain there. Now I'm going to accommodate you in that both the state and you will do your opening, your voir dire, your opening, the questioning of witnesses, and your closing arguments from counsel table. Now you can stand up at that table without your legs being seen because for the record, there's a skirt or the bench itself in front of you hides your feet. No one can see your legs. You understand that?
Yes, sir.
All right. So I've already told you that in the court's opinion, representing yourself is probably going to hurt your case, right? You understand, and I've said to you already that the state of Ohio is represented by a competent, experienced trial attorney, and that you will be held to the same standard as Mr. Arnold. You understand that?
Yes, sir.
All right. The rules of evidence and rules of procedure, even if you don't know them, will apply to you. Do you understand that?
Yes, sir.
I cannot assist you at all during the course of the trial.
Yes, sir.
You want to again understand that this is not a license for you to abuse the dignity of this court.
Yes, sir.
There will be no appeal for ineffective assistance of counsel.
Okay. Yes, sir.
Again, how old are you?
38.
How far did you go in school?
Dropped out.
So are you able to read and write?
Yes, sir.
Are you on any type of medications or drugs?
No, sir.
Do you have any prior experience in representing yourself?
Not representing myself. I've always had good dialogue with my attorneys.
Okay. Do you have any prior experience, your prior experience in the legal system?
Just being charged with stuff.
Okay. You don't have any formal training in the law?
No, sir.
All right. And you have no mental deficiency or conditions that would interfere with you understanding what's going on here today?
Not that I'm
All
able,
right.
though.
Now tell me once again, is it your intentions, is it your desire that you want to proceed in this trial representing yourself?
I'm pretty sure.
No, you got to be certain.
I mean,
Why don't we do this? Why don't we do this, Mr. Jones? Let's allow Ms. Martin to represent you, and if something happens and you can change your mind later, it's easier to go that way than to go the other way. You can't have it both ways. What's that?
I use the bathroom, please. I really gotta go, sir. I just need to use the bathroom. I'd be a lot more focused and stuff. I really gotta use the
All right,
bathroom.
Rhodes, take him to the bathroom. I'm not going to go over this with you again.
That's
You have this
fine.
one last opportunity.
I understand, sir.
All right. Take him, let's go off the record. All right, we are back on the record in the state of Ohio versus Aaron Jones. Mr. Jones, you've had your second trip to the bathroom now. I take it everything went better?
Yes, sir.
All right, now, you have in front of you a form called waiver of counsel. I've gone over with you all of the elements of granting that waiver. Do you still wish to proceed as your own counsel?
I need to get some I need real counsel. I talked to my family. They was talking about hiring a lawyer. I thought it was a little more cut and dry. I had a little more confidence in Ms. Martin than that. And just at this point in time, I'd rather just wait on my family to get a lawyer for me.
But that's not going to happen. This case is proceeding to trial today.
Well, I'll represent myself then.
You want Mrs. Martin
No,
to...
I don't want her near me, around me, or nothing. She can.
All right, sign the form in front of you.
What's the date?
Today's the 18th. All right, Ms. Martin, you'll stay behind Mr. Jones as standby counsel. Mr. Jones, that's your signature, sir?
Yes, sir.
And you read this document?
No, not really. Why is Miss Martin here?
Because I'm making her a standby counsel in case there's an issue. She'll be in the back of the courtroom.
I don't need
Mr.
no
Jones, I don't care what you want with regard to that. I'm following procedure, and this is what we're going to do. Read the form, please.
The whole reason.
Mr. Jones, read.
Of representing myself was because I didn't trust the lady. That was the
Okay,
whole purpose of
she's
that.
not,
She's still here and attached to my case. That's the
She's
whole
removing
purpose of
herself-
I'm removing her. Was for me to be able to represent myself.
You will be. Sign the form. Read
It was
it.
already signed. You
All
already
right,
seen my
read.
signature. You already
I'm sorry, I
asked me my
misspoke.
signature. You see my signature was on that shit. You already said it was there. What are you talking about?
Read the form. You said you
I already
didn't read
signed
it.
it, man. It's cool. Go ahead.
Read the form. Are you able to read and write?
Sometimes. Depends on how many pictures are on.
You done?
I ain't read it. I
get the
already
form.
signed it. We already went over it. It's cool.
All right, the court will make a finding then, sir, that you've made a knowing, intelligent, and voluntary waiver of your right to counsel, and the court will accept that. Ms. Martin will stay in the courtroom as standby counsel. Other than that, are we ready
to
to...
Ms. Martin is standing by counsel.
Mr. Jones, I'm going to tell you one...
Counsel.
Mr. Jones, I'm going to tell you
I'm not allowed
one...
to object. I'm my own counsel now. I'm allowed to object, ain't I?
Then you say the word objection.
I did. I said I object.
What are you objecting to?
I'm objecting to Ms. Martin stand by as counsel. I'm representing myself. I'm objecting to having her here. I don't trust her. So that's the whole reason of me releasing her was to represent myself because I didn't feel confident with her abilities, nor did I feel confident enough with her not working with the prosecution in order to help lay down and obtain a conviction. My removing of her was
All right, stop.
based on...
Stop. Your objection is overruled. Ms. Martin will stay in the courtroom as acting counsel. Standby counsel, sorry. All right, are we ready to bring the jury down?
Yes, Your Honor.
All right, bring them down.
Let's put this whole hearing together. Aaron Jones, already incarcerated, facing a third-degree felony assault charge with a maximum of 36 months, insisted on representing himself against a prosecutor with 46 years of trial experience on the exact day his jury trial was set to begin. Along the way, he couldn't explain what mitigating circumstances are, flip-flopped on whether he even wanted an attorney, took 2 bathroom breaks in the middle of his own constitutional rights hearing, and ultimately signed a waiver form he admits he didn't fully read. And yet, the court found that waiver knowing, intelligent, and voluntary while still keeping his rejected attorney in the room as standby counsel, a safeguard Jones himself objected to. It's a genuinely remarkable balancing act. The law requires the court to respect a competent defendant's right to represent himself, even when every signal in the room suggests that decision might not go well. So we'll leave you with this. Knowing everything you just watched, the confusion over the charges, the reading admission, the constant reversals, do you think Jones was truly competent to waive his right to counsel? Or did the court let this go further than it should have? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.